Assalamualaikum and hi, my name is NASHZEIRATUL Alleiya BINTI MOHAMAD ZAMRI. My nomenclature is 01 DDT 20F1006. I'm from class DDT S4. I will present you activity 6, cyber law about case intellectual property. So let's go. Patent infringement case injunction and FRND declaration. Apple vs Samsung case. The Grand Panel of the Intellectual Property High Court decided on May 16, 2014, Case No. 2030 NA 143, Appellant Defendant Samsung Electronics Kabushiki Kaisha, Appellant Plaintiff Apple Japan Godo Kaisha. Summary. In a declaratory judgment action filed by Apple Samsung Electronics Japan, patent was found valid and infringed by some Apple products. The liability for damage was assessed under the FRND declaration Samsung made when it entered the Japan patent into the UMTS technical standard for mobile communications. The amount of reasonable royalty was determined under FRND condition to be JPY 9,955,854 or about $82,000. Also, into accompanying decision that result from preliminary injunction action, it was concluded that Samsung demand for injunction on Apple product amount to abuse, use for right and injunction are not allowable due to FRAND declaration. The decision have become final because Apple and Samsung settled to abandon all litigation in Japan. Apple Japan, a Japanese subsidiary of Apple, sought a declaratory judgment of non-existence of liability under a Japanese patent to Samsung Electronics K. A Japanese subsidiary of Samsung Electronics Co. Ltd. Japanese Patent No. 4842898A entitled Method and apparatus for transmitting or receiving packet data using predefined length indicator in a mobile communication system. According to US 7875941 (B2), Samsung Electronics failed to lawsuit against Apple Japan since preliminary injunction before the Tokyo District Court in April 2011 and December 2012. Apple Japan reject action in September 2011 was in response to this lawsuit. The IP High Court issued 3 decisions separately for each of the lawsuits on May 16, 2014. In the declaratory judgment action, 4 Apple products were subject of the dispute: 1. iPhone 3GS, 2. iPhone 4, 3. iPad Wi-Fi plus 3G, and 4. iPad 2 Wi-Fi plus 3G. The product in dispute comply with UMTS standard prepared by the Third Generation Partnership Project 3GPP, a non-governmental project set up among several standard setting organizations SSOS. One of the SSOS involved was the European Telecommunication Standard Institute ETSI. ETSI has an intellectual property right policy. Samsung followed this policy and notified ETSI that intellectual property right including the patent in dispute might be essential under the UMTS standard with a declaration that it was prepared to grant irrevocable license for fair, reasonable and non-discriminatory 51 FRND terms and conditions. There were issues of contention. 1. Whether Claim 8 of the patent covered the Apple product. 2. Whether the Apple product indirectly infringed Claim 1 method claim of the patent under Article 101, 4 and 5 of the Patent Act. 3. Whether Claims 1 and 8 are invalid. 4. Whether the patent is exhausted with respect to the Apple product in dispute. 5. Whether there was a license between Apple and Samsung on the basis of the FRND. Declaration of Samsung. 6. Whether the claiming of damage by Samsung amount to abuse use of right. And 7. The amount of damage. As to the question of patent exhaustion, issue 3, Apple argued that the baseband chip used in the product in dispute either released the product of Claim 8, device for transmitting data in a mobile communication system, of the dispute patent, or it used only for the purpose of releasing the invention received in Claim 1, method for transmitting data in a mobile communication system, and therefore this constitutes direct infringement or indirect infringement. According to Apple, Intercorp sold such chip to Apple under a license from Samsung, and the Samsung patent held as housed with respect to the patent in dispute. So, in the preliminary injunction lawsuit, two issues were raised. One, whether the Apple product mentioned above infringed Claim 8 of the patent, and two, whether Samsung demand for injunction amount to abuse use of rights. Held. In the declaratory judgment action, the Grand Panel of the IP High Court found that Product 2 and 4 mentioned above fall under the scope of Claim A, whereas Product 1 and 3 do not, and the 5 grounds of invalidity. Apple raised a moot. Thus, the patent in dispute was found to be a valid and infringed. As for the exhaustion theory, Apple urged, since Intel did not have a valid license from Samsung, and such license in any case would not have covered Intel subcontracting the manufacture of the chips to a third party and subsequent sale of the chip. The court concluded that there are no grounds of Apple judgment concerning patent exhaustion. Further, the court noted that even if it is assumed that a license exists between Samsung and Intel, as such license covered the chips in question, the enforcement of the Samsung patent will not restrict against the manufacture and sale of the Apple products that will fall within the scope of the Samsung patent were created using the chips which do not fall by themselves within the patent scope. The court also considered the meaning of the FRND declaration under French law because ESTI IPR policies is governed by the laws of France according to its Article 12, and conclude that merely being prepared to grant do not give rise to an actual license. No license agreement was established even if Samsung made the FRND declaration. 52. Also, the court held that abuse use of right may be found for any amount of damage beyond a reasonable royalty under FRND terms unless license on the part of the other party, but no abuse use would be found if a demand for damage remains within such reasonable royalty. Even if the patent is declared essential to the technical standard, right to obtain a reasonable royalty under the FRAND terms should not be restricted solely because the patent technology belongs to the standard. The court then calculated the damage award to be JPY 9,955,854 or about $100,000. In the published version of the decision, important numbers are read to protect trade secret. In the course of calculation, the court note that both parties mentioned the cumulative royalty of 5% with respect to the UMTS standard and used this figure. Also, the court note that 5 to 9 patent families are involved in the UMTS standard, and that the Samsung patent in dispute is not considered particularly important compared with other patents. The court divided the cumulative royalty by 5 to 9. For the preliminary injunction action, the IP High Court concluded that Apple's product 2 and 4 infringed the Samsung patent but demand preliminary injunction will be abuse use of right, and injunction are not allowable in view of the FRAND declaration. This decision marked the ninth instance of decision issued by the Grand Panel since the IP High Court started in April 2005. The IP High Court can choose a case and have it reviewed by the Grand Panel at its discretion. The original District Court panel headed by Judge Ichiro Otaka had summarily rejected Samsung's claim for both preliminary injunction and damage as abuse use of right, which is prohibited by Article 1 in the bracket 3 of the Civil Code, although the panel found the patent in dispute essential, valid, and infringed. In the decision for the DJ action, the court stated that the defendant violated an obligation based on the principle of good faith and trust to provide material information during the preparatory stage of a license agreement on FRAND terms concerning the patent in question and to faithfully negotiate. Also, the defendant continued to maintain, as of the date of closing judgment, petition for preliminary injunction order against importation and sale based on the present patent. Furthermore, it was more than 2 years later that Samsung reported the existence of the dispute patent to the ETSI after Samsung presented a request for a technical change that were eventually adopted as part of the technical standard. In consideration of the circumstance as well as other events that occurred during the license negotiation concerning the present patent, it is not allowed as it would constitute an abuse use of right to be for right to obtain damage based on the present patent on product 2 and 4. The current IP High Court decision is more nuanced and gives balanced consideration to many different factors and theories, such as the nature of the IPR policy of an SSO and patent exhaustion. They calculate a worth of the match about $100,000 is not less by any measure, but if we think of the fact that mobile phone and many tablets now use the 53 third generation mobile communication standard and 3G communication is only one of many features the device have, the award of the match that comes from only two Apple products may have to be small. In the published version of the court decision where specific numbers used for the match calculation are redacted, there is no sign of the court willingness to mark up an award because this is after all an infringement case. When the IP High Court announced that the Grand Panel would review this case, it also solicited public comment on the issue of FRND or RAND declaration and enforceability of a patent. This was the very first time any Japanese court solicited public comment on a civil case. 58 briefs were submitted to the law firms handling this case, as Japan do not have an amicus brief system. Public comments are collected by law firms and are then submitted to the court as part of documentary evidence. The IP High Court spent 2 pages of its 163-page decision summarizing the submitted comments and reflecting on them. Finally, it is all about the case of the Apple and Samsung on the patent. So that's all from me. Thank you. Sorry if I made a mistake.